Changing your onset date at or prior to your hearing may result in a fast approval. I'm Jonathan Ginsberg. I'm a Social Security disability attorney. I represent clients in all 50 states. I'm able to do that because right now the default for hearings is telephone or video. So where you live does not make any difference. Hearings are done, again, virtually by telephone or by Microsoft Teams online video. I want to talk to you today about what happens or why you should be aware of the possibility that changing your onset date, the date that you became disabled or you're alleging you became disabled, can make a real difference. And sometimes judges will issue a very quick approval when you do that. And the reason you might do it would be that the medical evidence shows that your disability became work preclusive as of a certain point, or your age status changed, you turned from 49 to 50, or from 54 to 55, and then grid rules apply. And it could be, again, those are the typical reasons for it. And a lot of times I will tell you that I see people who have a medical problem, and it may have been very, very severe, but they didn't go to the doctor, or the doctor's reports don't really say very much until a certain point. And that's when the medical record supports a finding of disability, and judges are going to look really closely at the medical record and when does it say this person became disabled. So let me give you an example, because I just had a hearing recently that literally lasted 5 minutes. I hardly had to say anything at all. And that's because prior to the hearing, I submitted a brief where I changed the onset date. Now, of course, I talked to my client about it. And this situation is one where my client stopped working in 2018. She's diabetic. And she stopped working because she was having trouble driving. She had an hour commute to and from work, so especially at night, she was having a lot of trouble driving, having trouble seeing, and so her employer wouldn't change her hours, so she stopped working. And she was having problems with diabetes, but she wasn't really going to the doctor very much. And you could sort of see when she'd go in, they would take blood sugar levels. They were high, but there was never any mention of retinopathy, which is the vision problems, or neuropathy, which is the numbness and tingling in the hands. There's really nothing in terms of complications. It would say diabetes is under control, but there was no specific complications. And that can happen if you're diabetic and your blood sugar is not under control, and even if you're taking the pills or insulin, for the first X number of months or years, you may have, out of control blood sugar, but there's no complications yet, no organ damage or no problems with vision or nerve problems. That may happen later on after you've had uncontrolled diabetes for several years. Can be the situation, or just simply can be you haven't gone to the doctor enough to have it diagnosed. So anyway, this lady stopped working in 2018, and by the way, not being able to drive, having trouble with transportation is not a factor in a disability determination. So for Social Security purposes, if you don't have transportation to get to a job or you don't like to drive, that is not a factor. That would eliminate jobs that require driving, but it does not make you disabled. The Social Security kind of assumes you can take an Uber to work and you could perform the job even if you can't drive, you don't have a car, you're not on a bus line. So driving is not a factor at all. So again, she stopped working mainly because she was having trouble driving, but there was nothing else in her record to say that she was having problems with functioning, which is really the key concept in a disability case. So I'm looking at the record, and again, I'm seeing her blood sugar levels being out of control for, month after month. She was going every 3, 4, 5 months, and really no discussion of complications. There was a couple of discussions of falling, which again suggests she was having trouble, feeling her feet or having control of her feet. But again, the boxes were not being put together. There was simply no discussion in the record that was the reason why. Fast forward to 2022. And she has a bad fall. Again, probably because of the diabetes, but she has a really bad fall. And she hurts her knee. She tears I think the ACL. I think she had a problem with the patella. It was a real problem, and she really is having a lot of trouble walking. She also is now 56 years old. So we go from a person who's 53 with diabetes but no complications to a person who's 56 with increased complications, and now the doctors are saying, yes, there are vision problems. Yes, there's some neuropathy, and connecting the dots as far as her fall. And now she has a situation where she has trouble standing and walking for more than 15 or 20 minutes because of a really bad knee. So she's changed age categories from 54 to 55. Now she's over 55. So the grid rules come into play. So we look at grid rule. Normally I'd look at grid rule 202.06, which talks about past work, but because she had not worked she was right at the 5 years, but essentially she hadn't worked in 5 years, she had no past relevant work for Social Security purposes. So we have a person with no past relevant work, over 55, with a bad knee, and pretty compelling argument she would be limited to, she could not perform light work, which would require her to be on her feet for more than 6 hours in a day and lifting 20 pounds. So a lot of things had changed. So by 2022, she meets the grid rule. Again, no past relevant work, limited to light work or less, and she's age 50, over age 55. So really lined up. So we get in there, and the judge looked at it. We walked, we go online. The judge calls everybody, and the judge is like, I read your brief, and I agree with you. She's now, meets the grid rule because she's over 55 and she can't do light work. I'm going to go ahead and approve her on the record. And the judge asked the claimant a couple of questions, but literally this hearing was over in less than 10 minutes. So that was a situation where I had told her beforehand, I said, look, we can try to argue that you became disabled in 2018. It's going to be a real uphill battle. If we go ahead and tell the judge we're going to agree that there's a stopping point or a break point, and realize that when she fell, that is something new in the record, the judge can hang her hat on that and saying that's when she lost the ability to stand and walk. She probably wasn't able to stand and walk very well before then, but now she's torn up her knee. And so again, everything kind of lined up. We had a specific incident to reduce her exertional capacity so she couldn't stand and walk. She's at that right age. She meets the grid rule, and the judge is like, I'm going to go ahead and approve that. So my point here is that if you have a situation where you're under age 50 or under age 55, and there is the medical evidence is a little maybe inconsistent, a little weak, you look at, well, maybe going to the next age category or maybe changing the onset date might make the judge's life a little bit easier. What you don't want to do is get the judge upset that you're trying to be greedy, trying to say that you're disabled when the medical evidence really doesn't say very much. And you've got to look. When I look at the medical evidence, I'm looking at it from the perspective of, if I was the judge, what would I do? And so, you don't want the judge to feel like you're trying to get something for nothing. And, judges are smart, and they realize that, people sometimes can't afford to go to the doctor. But on the other hand, they've got to be able to base their decision on medical evidence. So my client was, fortunately, she listened to me, and you should listen to your attorney about when the situation might be right to change the onset date. Now, I will tell you, on the converse, sometimes judges will say, let's change the onset date to your client's 55th birthday, when there's plenty of evidence that at age 53 or 54, this person was disabled. So you got to be willing to say no to that as well. Some judges try to just push it through, and I've said no plenty of times. And if the judge wants to deny or issue a partially favorable, we can deal with that later, possibly appeal it. But if it's a reasonable judge and the medical evidence lines up so that you can change that onset date, you're going to get a much happier judge. It'll be much faster, a lot less stress on you as the claimant. And it's just something you should be aware of, that in your case, this is something that might happen, so you're prepared for it. That's my big point. You want to be prepared for it if the medical record dictates that may be what's going to happen, and your attorney should be able to tell you that. If your attorney has done this for a while, it'll be pretty clear as to maybe this is a situation where the onset date should be changed. I hope you found this helpful. Please visit me online, ssdanswers.com. Also, on the YouTube channel, I go live with a live stream every Wednesday night at 8:30, almost every Wednesday night at 8:30. You can go there, ask questions. We go back and forth. I answer questions live. I'll have guests. So it's something I think you might find interesting. Please check it out. And again, on the website, ssdanswers.com, I've got a place you can download my Secrets to Winning Disability Survival survival kit. You can ask for a case evaluation. So I encourage you to check out all these free resources. I think you'll find them very, very helpful. So for now, this is Jonathan Ginsberg, and I wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.